Hello, everyone, and welcome to part 2 of Return to Campus Considerations. My name is Ragini Acharya. I am a Healthcare Regulatory Associate in the Husch Blackwell Denver office. I'm with my colleague today, Mary DeWeese, who is in our Chicago office, and she works in the education group. Today, we're going to be talking about employee and student accommodations in light of the COVID-19 pandemic and related concerns. So, Mary, to get started, what's going on in higher education right now? As a healthcare regulatory attorney, I've worked with Husch Blackwell's higher education group in helping our higher education clients plan for the return to campus. But what's going on now that the semester has actually started? I'm reading the news, and I see that some colleges have started in person and then had to temporarily move to virtual formatting due to cases of COVID, and others have planned for and are enacting virtual-only schedules, and while others still are completely in person. So what issues are you seeing as an education attorney right now?
So Ragini, every college and university is doing something a little different in terms of the format of their delivery of instruction. Like you've been seeing in the news, institutions all created plans that would work best for their campuses, student bodies, and employees based on the information known at the time. And then as the semester started and circumstances changed, some of those institutions have had to pivot. So I'm really excited that we're doing this so-called podcast on accommodations today, because the attorneys in our education group have been fielding so many questions, both in the weeks leading up to the start of the semester and in these first few weeks of classes, about accommodations in light of COVID-19 concerns. And as these institutions are pivoting, this issue is remaining really relevant.
So Mary, why do colleges and universities even need to be thinking about accommodations?
Well, as you know, the Americans with Disabilities Act prohibits disability discrimination. And the ADA applies to certain disabilities that might make somebody at high risk for COVID-19. So just as some background on the ADA, there are several titles in the ADA that govern employment, public accommodations, and public entities. And as a general matter, colleges and universities cannot discriminate against an employee or against a student on the basis of his or her disability. Now, our colleagues Demetrius Peterson and Teresa Molyneux are going to be doing a webinar on student health on campus on September 21st. And in this webinar, they're also going to touch on COVID-19 related accommodations, and they're going to discuss the ADA in more detail. But just as a very brief overview, the ADA requires that colleges and universities engage in what is known as the interactive process to provide reasonable accommodations. Now, there's no one-size-fits-all approach to what is a reasonable accommodation. And moreover, if a student or employee requests an accommodation, even if that requested accommodation is reasonable, the university could offer instead a different reasonable accommodation. And there are some, limitations to what sort of accommodations the university, has to offer beyond just whether or not it is, quote unquote, reasonable. For example, an employee must be able to perform the essential functions of his job with or without reasonable accommodation. And because of this, the ADA does not require that a university eliminate any, essential duties of a position. Likewise, while students with disabilities are entitled to equal access to education as their non-disabled peers receive, a college does not need to fundamentally alter its programs in order to accommodate a student with disabilities. And finally, an accommodation does not need to be provided to either a student or an employee if the accommodation would would cause an undue hardship to the university.
That's really interesting, and that's a really good background. What kind of accommodation requests then are these higher education institutions getting from employees and from students?
Well, there's a mix. That said, the bulk of what we are seeing is requests from employees to work from home or to work in a more socially distant location on campus due to concerns about COVID-19.
So are these requests coming from employees who are at higher risk versus severe illness or from complications from COVID, or like, as you know, the CDC has said that people with certain underlying medical conditions are at an increased risk, like those that have cancer or are suffering from kidney disease, heart disease, type 2 diabetes, like sickle cell, and those, with immunocompromised states are also at an increased risk, as well as like those with type 1 diabetes. Are these requests coming from these types of employees?
Yeah, a lot of the requests are coming from, from those types of employees. And you raised an interesting point. There are a lot of conditions that can affect the employee population. And as I was saying, this raises the question of what is the difference between a request from an employee with a pre-existing health condition such as COPD or type 2 diabetes versus a request from an employee who engages in a certain behavior like smoking that puts them at risk. As you know, just being a smoker alone might put you at high risk for complications from COVID. So, the requests for accommodations for employees are coming from those both with, some pre-existing health conditions, but also from employees who, are at risk for other reasons. And then also these requests aren't, only coming from employees who are high risk themselves, but also from employees who might live with somebody who is high risk.
So how does a person's risk of having complications or like a more serious case of COVID-19, if caught, interplay with the ADA?
Well, the EEOC has said that if an employee says he has a disability that puts him at a high risk for severe illness if he gets COVID, and on that basis requests an accommodation, that this is a request for accommodation due to a medical disability under the ADA, meaning the ADA and the interactive framework that governs ADA requests applies. But that said, and I'm going to quote the EEOC here, the employee only has a right to reasonable accommodation for his own disability, end quote. So smoking, for example, is not a disability on its own, and therefore, isn't a disability under the ADA. That said, a person who is a smoker may also have another disability, such as COPD or asthma or something, that could be a disability under the ADA. Likewise, while persons who are obese are in a high-risk category for COVID, certain courts, including the 7th Circuit, where I'm located, have said that obesity is not an impairment under the ADA. But again, a person who is obese might have a medical condition that is an impairment or disability under the ADA. So requests for accommodation really need to be evaluated on a case-by-case basis rather than by issuing any sort of blanket policy about, what will or will not be considered a disability for purposes of COVID-19 accommodations. Likewise, requests for accommodations based on an employee's family member's disability or their own family member's high-risk category, those requests are not governed by the ADA either. But any college or university that's getting these sort of requests related to an employee or a student living with someone who's at high risk, whether because the family member is disabled or is older, the college needs to consider how they are treating these requests and to make sure that they have a consistent practice in terms of whether they're going to prioritize work from home, telework, remote, some sort of social distancing placement on socially distant placement on campus, for such persons. They just need to make sure they have a consistent practice when it comes to these non-ADA, sort of requests.
All right. So, what sort of accommodations then would be considered reasonable? Throwing a hypothetical at you: if an adjunct faculty in the philosophy department has diabetes and is requesting that she be able to teach her class online for the semester, is this type of request something that the college should grant?
Well, accommodation requests are really fact specific. So there's no blanket answer to this. Some considerations are, as a preliminary matter, if the college is entirely online this semester, the request won't even occur. But what if half the classes are being taught online, to sort of, address the fact that some students want to be in person, some students want to be at home? Or what if the semester has started and the campus is, experiencing a spike in its cases that makes this professor nervous? So the question really is whether there's a reasonable accommodation that would allow this faculty member to teach her philosophy class and keep her own exposure to COVID-19 low without causing the college an undue hardship and without, fundamentally altering the college's program. So at some schools, the answer might be, a somewhat easier, yes, you can have her work from home or teach remotely. At a lot of others, it's going to require more of an analysis.
Okay, well, many colleges went online last year very successfully and are either partially or fully online this semester. So it seems likely that this history of being able to permit employees to work from home will be a factor. It should be provided again.
Yeah, I think it's definitely a factor. That said, as I said earlier, like the ADA doesn't require, a fundamental alteration to a program. And so, there's a lot of talk right now about whether or not virtual classes are, fundamentally different than in-person classes. And so whether or not, the history of, having everyone being taught online last semester, should be a consideration as to whether or not to grant, a request to have a request to be able to teach remotely this semester. There's just no easy answer to that, but it's definitely something that, the college is going to have to look at and to determine whether or not, it went well when this teacher was, when classes were being taught online last semester. And, as I was saying, the extent that there are classes being, taught online this semester, and that's something that students are wanting, that might be a factor too. And of course, we're talking about a philosophy, teacher who presumably is in a seminar setting. So maybe that's easier to, teach over video. What if the professor is in a chemistry lab and, where students have to be in the lab to do experiments, and moreover, those classes, couldn't occur last year due to COVID when the school went online. Similarly, what if the professor, teaches in a clinical program where students need to be in person to get enough hours for their licensure? Then the work from home accommodation seems like it's maybe even more likely to cause an undue hardship or a fundamental alteration to the college. So these are all things that, a college really has to think through. But even if a work from home situation is not reasonable, there could be other accommodations that are reasonable and would not impose an undue burden on the college. For example, maybe a plexiglass shield in front of the professor's desk, or perhaps if space is available, permitting the professor to teach in a larger classroom where there's more space to socially distance. Like I said earlier, there really is no one size fits all. So on that note, how about a hypothetical for you? There's a 70-year-old custodian in the dining hall who does not want to return to campus to work. What does the college do?
Well, as you know, age isn't a disability under the ADA. And while the Age Discrimination and Employment Act prohibits discrimination based on age, the ADEA does not have a reasonable accommodation provision. So there's no requirement that a person be accommodated solely because of his or her age.
But if the college wanted to, it could grant accommodations based on age, right?
Yes, it can. While the employer can't treat older workers less favorably than younger workers, it can grant accommodations to older workers that could result in them being treated more favorably. For example, if it is not an undue burden to allow some staff in a department to telework, but not all such staff can telework without creating such a burden, the university can prioritize telework requests to people with disabilities and people over age 65 without running afoul of the ADA or the ADEA.
That makes sense. And of course, there's probably other disabilities that a custodian could have, which would entitle him to a reasonable accommodation, just like that obesity and smoking example as we talked about earlier.
That's a great point. So let's change the hypothetical then to a custodian with, say, sickle cell. A request to work from home wouldn't likely be reasonable, as being on campus to clean is an essential function of the job. However, he's currently working in the dining hall, and this is a high-traffic area. The college could consider whether there's a reasonable accommodation, such as being assigned to clean an administrative office or being assigned to work hours where the building is closed. And that would allow the custodian to complete the duties of his job without increasing or substantially increasing his risk of contracting COVID. And also, this is beyond the scope of our discussion today, but employers should make sure that they're abiding by any leave-related laws if an employee is unable to safely work due to COVID. So, Mary, what other types of accommodation questions are coming up in your practice?
So we've been getting a number of questions relating to requests to not comply with COVID-related protocols. For example, on our last episode of this series, we spoke about testing programs. And so at schools with surveillance testing programs, there are requests coming in to be exempted from those, periodic testing requirements.
On what basis are these exemptions being requested? Does the ADA prohibit these sorts of tests or require exemptions?
Well, as an initial matter, the EEOC has said that COVID-19 tests that are administered in a manner consistent with CDC guidance are compliant with the ADA. The ADA expressly permits mandatory medical testing when it is, quote, job-related and consistent with business necessity.
Okay, well, as we talked about last time, the CDC has said that testing for COVID-19 on an initial and periodic basis is recommended for early identification of asymptomatic individuals in settings, especially where COVID can spread rapidly. And like we said last time, that's a college campus. So testing all employees who are working on campus periodically, regardless of symptoms, should be ADA compliant under the EEOC guidance.
Yeah, likely yes. And as we said last time, the CDC wasn't recommending initial testing at that time, but like you pointed out, it was this initial and periodic testing, in specific situations in specific settings such as residential living communities, that are on residential campuses. So yeah, it should be ADA compliant. But that said, in addition to reasonable accommodations under the ADA, reasonable accommodations for disabilities, there are other laws that require an employer to provide accommodations on other bases. Specifically, Title VII of the Civil Rights Act requires employers to accommodate sincerely held religious beliefs, and there also might be state laws that apply. So religious beliefs and practices must be accommodated if the requested reasonable accommodation will not impose more than a de minimis cost or burden on business operations. Generally requests for religious accommodations arise, for example, in a request to not work the Sabbath or a request to be permitted to take time during the workday to pray. But particular to COVID, there could be a religious reason that an employee, doesn't seek medical diagnosis or treatment, and perhaps even doesn't want his or her blood drawn. That said, if an employee states a religious objection to participate, in a testing program or a symptom monitoring program, this alone does not require the college or university to permit such an exemption. Again, the religious belief has to be sincerely held. Usually whether someone's religious belief is sincerely held isn't in question, but if there's an actual basis to doubt that it's a sincerely held belief, perhaps there's prior inconsistent behavior with that religious belief, or the timing of it, is suspect, that is, the employee has never brought this up before and now is bringing it up only now and has acted previously in a way that, calls into question whether the belief is sincerely held. The employer then, is entitled to make a limited inquiry into the sincerity of the belief. But this is really the sort of situation where an employer wants to seek out legal advice before responding to the, accommodation request or engaging, in any sort of inquiry into it. Also, as with a request to accommodate a disability, Any sort of, exemption-based accommodation request on the basis, of a religious belief could impose an undue hardship on the employer, in which case it doesn't need to be granted. So, that's one way that a request to be exempted from some sort of COVID-19 protocol could arise, but much more commonly, we're seeing that sometimes the employee is just simply saying that he or she is uncomfortable with the requirement to participate, particularly with, surveillance testing programs. And an employee's just, general discomfort, not based on disability or religion or any other protected status, does not need to be accommodated.
Okay, so to restate what you just said in a different way, while any request for a disability or religious-based accommodation that would permit an employee to not be subject to a surveillance testing program should be considered and evaluated on a case-by-case basis, if the program complies with CDC protocols and complies with any relevant privacy laws, is otherwise constitutional in terms of its status as a government quote-unquote search, et cetera, the university can require that all employees participate in the program without exception.
Yes, exactly. College and university policies aimed at mitigating the spread of COVID-19 are necessary for these institutions to attempt to provide in-person classes, keep their residence halls and cafeterias open, keep students, faculty, staff, all visitors, employees, et cetera, safe. So as such, compliance with certain precautions, is required for employees and students, just as compliance with, university policies has always been a requirement. And of course, if the situation does arise where an employee is entitled to an accommodation, related to a testing program or any other COVID-19 protocol, it is quite likely permissible that an alternative practice, be required. That is, the university doesn't have an obligation to, issue an exemption. It has to issue an accommodation. And in most cases, there will be, some alternative practice that's a reasonable accommodation, rather than any sort of, blanket exemption.
On this note, another issue relating to accommodations in COVID-19 is requests for exemptions from mask requirements. So some faculty, staff, and students may request an accommodation to a mask requirement based on wearing of religious garments. Others may request an exemption based on medical conditions affecting breathing or making mask wearing painful. The CDC has enumerated the limited circumstances in which masks may not be feasible, which really only includes those under the age of 2, when a mask would make breathing difficult, such as when swimming, or those that are unconscious, incapacitated, or otherwise unable to remove a mask without assistance. However, there may, depending on the context, the employee is working if the student is attending class, be reasonable accommodations made to a face mask requirement, such as permitting the use of face shields instead. Again, accommodations requests should generally be considered on a case-by-case basis. And I know that in the September 21 webinar we mentioned earlier, Teresa and Demetrius will further touch on the face mask versus the face shield issue.
Before we wrap up today, what do you think is the most important takeaway or set of takeaways for universities to consider when it comes to requests for accommodations related to COVID-19?
Well, I'll say it once and I'll say it again. As always, communication is key. Colleges and universities can, and in most cases should, include in their written COVID policies that requests for accommodations will be considered on a case-by-case basis, and they should provide information about whom the request should be made.
I agree completely. And I just want to add that, as we've seen across the country in the lead up to the start of the semester and the first few weeks of class, flexibility is necessary. Institutions are being responsive to the situation on the ground, and as those situations evolve, for example, moving to online courses on a temporary basis in response to a surge of cases, or deciding to start next semester on campus after having this semester online, as those situations evolve, what accommodations are or are not reasonable, or will not impose an undue burden or create a fundamental alteration may change.
Right. Yes. And this is why we'll be touching on a very specific aspect of campus closure, moving to online courses in one of our next podcasts. That is, what considerations specific to academic medical centers or universities that have students in clinical programs should be front of mind when contemplating a switch from an in-person to an online mode of instruction delivery.
Yes, and we'll also be recording an episode addressing privacy concerns relating to testing, contact tracing, and the disclosure of positive cases. So, we hope that, our listeners join us for those, those upcoming 2 episodes. And if anyone has any questions about this episode, about accommodations, or about what we talked about last time regarding contact tracing and testing, please reach out to us. Our contact information is on the last slide, or if you're listening virtually only, you're listening to audio only, you can go to our website at hushblackwell.com to find us. Thank you for joining us today.